Right to equality before courts and tribunals. General Comment Number 32, 2007 of Human Rights Committee. 2. Equality before courts and tribunals. 7. The first sentence of Article 14, Paragraph 1 guarantees in general terms the right to equality before courts and tribunals. This guarantee not only applies to courts and tribunals addressed in the second sentence of this paragraph of Article 14, but must also be respected whenever domestic law entrusts a judicial body with a judicial task. 6. 8. The right to equality before courts and tribunals in general terms guarantees, in addition to the principles mentioned in the second sentence of Article 14, Paragraph 1, those of equal access and equality of arms, and ensures that the parties to the proceedings in question are treated without any discrimination. 9. Article 14 encompasses the right of access to the courts in cases of determination of criminal charges and rights and obligations in a suit at law. Access to administration of justice must effectively be guaranteed in all such cases to ensure that no individual is deprived, in procedural terms, of his/her right to claim justice. The right of access to courts and tribunals and equality before them is not limited to citizens of states parties, but must also be available to all individuals, regardless of nationality or statelessness, or whatever their status. Whether asylum seekers, refugees, migrant workers, unaccompanied children or other persons, who may find themselves in the territory or subject to the jurisdiction of the state party. A situation in which an individual's attempts to access the competent courts or tribunals are systematically frustrated de jure or de facto runs counter to the guarantee of Article 14, Paragraph 1. First sentence, point 7. This guarantee also prohibits any distinctions regarding access to courts and tribunals that are not based on law and cannot be justified on objective and reasonable grounds. The guarantee is violated if certain persons are barred from bringing suit against any other persons, such as by reason of their race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. 10. The availability or absence of legal assistance often determines whether or not a person can access the relevant proceedings or participate in them in a meaningful way. While Article 14 explicitly addresses the guarantee of legal assistance in criminal proceedings in Paragraph 3d, states are encouraged to provide free legal aid in other cases, for individuals who do not have sufficient means to pay for it. In some cases, they may even be obliged to do so. For instance, where a person sentenced to death seeks available constitutional review of irregularities in a criminal trial, but does not have sufficient means to meet the costs of legal assistance in order to pursue such remedy, the state is obliged to provide legal assistance in accordance with Article 14. Paragraph 1, in conjunction with the right to an effective remedy as enshrined in Article 2, Paragraph 3 of the Covenant. 11. Similarly, the imposition of fees on the parties to proceedings that would de facto prevent their access to justice might give rise to issues under Article 14, Paragraph 1. In particular, a rigid duty under law to award costs to a winning party without consideration of the implications thereof or without providing legal aid may have a deterrent effect on the ability of persons to pursue the vindication of their rights under the covenant in proceedings available to them. 12. The right of equal access to a court, embodied in Article 14, Paragraph 1, concerns access to first-instance procedures and does not address the issue of the right to appeal or other remedies. 13. The right to equality before courts and tribunals also ensures equality of arms. This means that the same procedural rights are to be provided to all the parties unless distinctions are based on law and can be justified on objective and reasonable grounds, not entailing actual disadvantage or other unfairness to the defendant. There is no equality of arms if, for instance, only the prosecutor, but not the defendant, is allowed to appeal a certain decision. The principle of equality between parties applies also to civil proceedings, and demands, inter alia, that each side be given the opportunity to contest all the arguments and evidence adduced by the other party. In exceptional cases, it also might require that the free assistance of an interpreter be provided where otherwise an indigent party could not participate in the proceedings on equal terms or witnesses produced by it be examined. 14. Equality before courts and tribunals also requires that similar cases are dealt with in similar proceedings. If, for example, exceptional criminal procedures or specially constituted courts or tribunals apply in the determination of certain categories of cases, objective and reasonable grounds must be provided to justify the distinction.